Hi everybody, Peter of England bringing you a video today concerning events that are about to transpire in the United Kingdom on a monumental stage. This coming Saturday, today being September the 11th, the September 13th rally in central London is probably going to be very eventful. And so unashamedly, what I'm trying to do is to dynamize and direct people's attention to the fact that changes are afoot. The world is changing, the UK can hopefully change, and to that end, what I'm showing you today is a new document for anyone out there that has bailiffs, debt recovery, or other agents trying to take them to court on supposed debt burden. So the document that I'm going to show you is an unashamed representation of the state of the United Kingdom. The flag is on there for a reason, and as you might have seen at the bottom of that document, it actually does state "my turn." So that actual page on the actual document itself is at the very end of the document, at page something like 124. That gives people the opportunity to either bear the document like this, or if they want to be more patriotic, should we say, they can carry it like this with the cover in position. Now, the nature of this document: if you buy this document, I will guarantee you a place in the various workshops that we're going to be holding in November, December, and early January into 26, based upon looking for individuals who not only wish to learn the material, but also might want to act as facilitators. And what I mean by facilitators is if you've got a penchant for educating, if you want to teach other people how to use this material, then what we need to do is go from a workshop to training other people to do it. So in effect, the workshops are working through the practicalities of the main how to defeat debt buyers. Pen running out a little. So, most of you out there are at some time probably going to be facing bailiffs knocking at the door, letters from debt recovery agents, or the main principal, indeed, if it is a bank, threatening you with court action. Now, what happens in a lot of instances, the actual main original lender sends threatening letters up until a point, and when that point is reached where they are deeming it to be unpalatable, unresolvable, what they'll do then is they will put that into a debt book and they will then sell it on to a debt collector. To give you some idea of the size of this market in the UK, that is the size of it. Approximately £35 billion a year, of which around about 4 billion is the amount recovered. So, as you can imagine, it is a very, very large operation and very fruitful. Now, the problem is that in most instances, of all cases that go to court, 80% are what's known as default judgments. That means the individual concerned does not turn up at the court. Of that 80%, so that gives us approximately 20% that maybe do turn up. Of that 20%, 90% lose these cases for 10 principal reasons that I mention in the document. the overall statement is you have to open your mouth, you have to attend court, and you have to show certain things in the what's called evidence and pleadings to help you win your case. In many of the instances, the debt buyers do not even have a legal title to the debt. That's because that in what's called the purchase agreement that is part of their claim, it's called a purchase agreement and what's called a forward flow agreement. There is usually a disclaimer notice within the purchase contract. So when that attorney or lawyer or paralegal is standing up in court saying things to you like, well, Mr. Jones, you did take out a loan from Amex or on a credit card, and this is your address, and it states here that you owe £10,000. Did you pay off that loan? You might tell the truth and say, no, I didn't. Then he might say, so you admit that you owe that now to our client, which is the debt recovery agent, Cabot's, Lowell's, whoever they're called, Midland Recovery. And you should answer on that truthfully. Well, no, I'm not sure that I owe it to your client or the claimant, because you don't actually know. And the reason you don't actually know is that what happens with these debt books is that the original amount of debt, let's say it runs to 100 pages, what they'll do is the purchase agreement might be 100 pages, but they will only produce maybe a face copy in the court. Now, what that does is it violates what's called the rules of evidence, because there is something called a best evidence rule, and that's attached to the proof of sale. Without digging into it too deeply, the best evidence rule stipulates that if a document is being entered into the record as proof of something, then unless the defendant challenges it, then the judge has no reason other than to just allow it to pass through. However, because that evidence is being entered into court as what's called hearsay, it has to comply with something called the business exemption for the rules of evidence within pleadings. Okay, otherwise it would be classed as hearsay. Now, not only that, but invariably a witness will be produced. A witness will be brought there in court, and he will sit there when it's time for him to be examined by the plaintiff's solicitor or paralegal, and he will answer the questions all preloaded. But then, if you don't turn up in court, if you do turn up in court but don't know how to ask a question, then you're going to be in trouble, and the judge's got no option other than to give a default judgment against you, because you fumble the ball, you mess it up, you don't really know what you're doing. So the idea of the workshops is to show you how to role play, how you will know the questions, 1, 2, 3 to ask. And one of the bigger ones will be that the witness in the box must have personal knowledge of the debt document. So, for example, if you ask him in cross-examination, do you have any experience whatsoever on how American Express Bank puts together its debt book? He'll answer, no. Have you ever worked for American Express and had them train you on it? No. So in effect, these questions are leading into the fact he doesn't really know much about it. He's just there to substantiate the piece of paper that the paralegal or attorney is holding, and they're expecting it to just be waved through. Now, the main argument with all of this is the following. And it's very important, and if any of you are taking legal advice and they're representing you in court, you have to ask yourself, why are they not following through on this? And one of the things is that the plaintiff, holding up the piece of paper saying that you owe Amex £10,000, they might be able to prove that you owe that debt. That's okay, that's a hands up, no problem. However, what they cannot do, and invariably find it impossible to do, for the reasons I'm going to give you in a moment, is the fact that they cannot prove that they own the debt. Okay? So, admissible, something that's admissible in court, is not the same as reliable. And reliable, or reliability, all comes down to what's called proof of assignment. In the UK, this comes down to the Law of Property Act 1925. And just before I go on, what I'm speaking about here, these rules of evidence and pleadings, apply to the whole world. Okay? If you're in Alabama, if you're in Minnesota, if you're in California state, if you're in Australia, if you're in any other Commonwealth country or Ireland, doesn't matter where you are, the procedures are the same. They've all evolved and devolved from Uniform Commercial Code, Lex Mercatoria, British common law, exported out to the world. So doesn't matter where you are, so don't think, this doesn't apply for me. If you've got a debt, somebody's chasing you in court, you need this document. Okay? So that's the crux of the matter. They cannot prove the assignment because under the Law of Property Act, the only thing that can be assigned are two things, in effect, as property. One is called a shows in possession. That means a physical object like land or a pen or a car. And the other thing is what's called a shows in action. That's something like the rights to music. That's something like a copyright, but not the actual material. It's something like the debt. Now, don't forget, what is it that the so-called debt buyer thinks he's bought? Well, what he's only bought is an accounting, a record. Now, that in and of itself might be okay, might qualify as what's called a shows in action. But for the shows in action, for that to qualify, it has to be unconditional and unequivocal. Okay? So, if you don't know these things, you are going to get blown away. Your court case is already over, finished, the gavel's already come down. Next, please, says the judge. So, what you've got to remember is that, because you don't know, on the purchase agreement, it's called a purchase agreement and a forward flow agreement, that the original bank or lender, like American Express, or like Santander, or Standard Chartered Bank on their bad loans, what they've done is they've put all that together and now they've sold it on to the bidder, which is the debt buyer. Big, big industry. And the debt buyer has had to do two things. When he's accepted the loan book, the accounting record, he's actually paid pennies on the pound. He's paid something like probably no more than 10p or 10 cents on the dollar or the pound. So, there's a principle here called unjust enrichment. in contractual law, they're only allowed to recover their losses. If they haven't made the losses, then what's going on here, Judge? So these are the points that you need to be able to drive forward. The next thing is that within the purchase and forward flow, what forward flow means is the ongoing debts that they're going to feed to them over the months and years ahead. Within that, there is invariably a caveat. There is a caveat, and so there's a caveat. There is no guarantee. There is no claim that the record is accurate. Now, what that means is, for an assignment under the Law of Property Act to be valid, don't forget, it must be unconditional. It must be tangible, and it must be real. Yeah, real as in viable. And with this clause in the purchase agreement, that means that the very, very, very best title that is going to be passed to the debt buyer is an equitable title. Are you all following this? I hope so, because this is brilliant. This is brought to you, by the way, by me, but in association with Freeman Legal Services and lawyers that have been working on this material for the past 25, 30 years and do actually litigate like this. So this isn't made up and this isn't conjecture. What I'm doing now is bringing this to the fore for you and offering this, the workshop idea. So what you now have is an equitable title at best given to the debt buyer. And with the equitable title, for them to progress the claim against you in the court, and here's the biggie, they must join with the original party. So if they don't join with American Express, then it's invalid. So now they're struck out in various ways. Bear in mind that the judge is there only because of commercial necessity and to facilitate this stuff moving through the system. 80 to 90%, so 80% are our default judgments because nobody turns up. 90% of the 20 that go fail because they don't know what to ask or how to frame their questions. And so what we find then is these situations arise where the judge is doing nothing more than going to himself, really, well, he didn't ask, so what am I supposed to do? I'm not here to make his case for him. He should have got a lawyer. And even if he gets a lawyer, the lawyer probably wouldn't challenge him much because they just pass it through. So that's the type of internal conversation that's going on. And so if you don't say to the judge, Judge, very well that the guy's waving a piece of paper saying that I owe this debt, but I'd like to see the book entry. I don't want a heavily redacted document. And if the purchase agreement stipulates these things, well, let's see it. The attorney or defense attorney, plaintiff, paralegal will go, no, you don't need to see this. There's nothing in it. It's all quite good, Your Honor. There's nothing in there that would bias our client's case. And, you know, he would even then say to you as the defendant there, you don't actually think the judge would allow me in the court to create this case against you if our documents weren't in order or we didn't have an absolute legal right to take this money from you. We haven't even touched on the unjust enrichment and the fact that they have made no loss so cannot claim. So, as these things aren't brought to the fore, then they just die on the vine. The judge just lets it go because of commercial necessity and just general, what do you call it? General process of the court. It's just going to get waved through. But if you insist, right, I need more proof on this. It's no good them saying you owe something, or you saying to the judge, well, yeah, I got married in December, Judge. I can prove it, no problem. I think it was the first week of December, 5th, could have been the 7th. No, okay, let's not argue about it. Just bring the proof. Bring the marriage certificate. That's what we will show. When did he die? I think it was January sometime. Okay, death certificate, please. It'll show exactly the date it happened on. So we don't want to get into this woolly area of acceptance, and this is one of the reasons most people lose if they're going to court defending themselves. They don't answer the questions truthfully. They think, because the paper's being handed over and that they do owe this supposed money to American Express, they think they owe it also, therefore, to the debt buyer. But title has not passed. There's a Latin maxim, begins with nemo dat. That means a title can only be passed as good as it is. So if they don't have the title, they can't claim assignment of it. So I'll just check that I haven't missed too many things here. The purchase agreement we've covered. Equitable only title on assignment. That's the best they've got. They've only bought accounting. They've only at that point, with the disclaimer in the warranty that was with the purchase of the debt. An interesting point that not many people know, not many lawyers would know even, because they never read the document, and it's the following. American Express, Santander, Commercial Bank, Commerce Bank, whichever bank it is, what they don't want to be seen to be doing is actually persecuting or hoisting the clients or customer base on the actual debt that they've encouraged them to take out. You can see, banks aren't losing money in the world. Banks are making good money, okay? And very well and very consistently. So they don't want to be seen to be the people taking them to court. That's why they send lots of nasty letters, etc., and eventually they give up and maybe sell it on to someone else. Not all, but most. Now, what also can be contained, and invariably does, in the purchase and forward flow agreement, is a stipulation that the debts aren't even suable on. Yeah? That means they are precluded from suing on it, but what they're doing is they're buying distressed paper, the debt buyer. That's what they're doing. They're on a wing and a prayer, and as nobody asks to see the purchase agreement, the judge doesn't even know that that clause is invariably in there. Now, a very good thing which is taught to you in here, part of the educational process, is an actual defense and a piquing of the judge's interest by coming up to the judge and saying, Judge, it's not actually me that they don't want to read the purchase agreement. It's you. Because if you read it and you see what's contained in it, then many of the cases, possibly, would have to be reassessed. Now, don't forget, you're not there on that particular occasion to do anybody else any favors. This isn't a Don Quixote charging at the windmill, being some type of vigilante freedom fighter. It's just defending your own case at that moment in court. So you don't really care what's happening to anyone else. All you want to make sure is that that paralegal fumbles the ball, that attorney thinks to himself, wow, okay, didn't expect any of that, and makes the judge say, okay, there's lots of points here. And so what you're looking for is the judge to be able to go, you haven't been able to prove any of these things, you should have got your case better in order, therefore not proven. And you go your merry way, and that's the end of the situation. Because don't forget that the debt buyer, you're just a statistic going through the court on that day. There can be probably a list of 10, 20, 30 individuals that are all there on the day being processed by that one paralegal or that attorney to get those cases through. Wave you through. That's what the judge will do if you don't contest this or open your mouth. Shows in action, as I've mentioned before, must be absolute. It cannot be conditional. It cannot rest on the disclaimer of the original purchase agreement, because it's then conditional. Do you see that? It's very subtle, but they've bought nothing. They've bought a maybe, a possibility. They've had to sign a document which actually stipulates the accounting might not be accurate. It may have already been paid off. Someone else could have tried and lost the case. And now they're trying to resurrect it like Lazarus, or give it, cardiovascular treatment, the paddles on the heart to bring it back to life. There's lots of things that could be going on. So the attorney there, he cannot, I assure you, he cannot prove that they own the debt. That's it. So we're going legal here. We're using their system to defeat their system. So this doesn't rely on Magna Carta, Section 61. It doesn't matter by asking the judge whether he's on his oath. It doesn't matter about freeman arguments, courts of record, etc. This is real world stuff, and that's all you're looking to do on the day. So I think I've covered just about everything. What you need to do now is go to removement.net and shop. Find the document, which will, because I've said it's actually presented like this. That's the document you'll be seeing. So buy it. You need it, I assure you. And this is a celebration now, a celebration offering of an early Christmas present for you. I assure you that most people, with just 4 or 5 of the questions out of this 120-odd page document alone, will be able to either, at the very minimum, stop the case or have it adjourned, but invariably will be able to show that the claim by the plaintiff is invalid. So it's worth it. Now, in addition, as I say, you buy this and I guarantee you a place on the workshop. If you don't buy the document, you might be able to still get on the workshops, but so if you want to become a facilitator, as I mentioned before, fine, you need it. And if you're being chased by bailiffs, debt collection agencies, law firms, and even the original lender to an extent, then this document is a must. Okay? Thank you.